The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du tribunal pénal international pour l'ex-Yougoslavie est ouverte. Please be seated.
Yes, let the registrar call the case.
Good morning, Your Honours. Case number IT 0254T, the prosecutor versus Slobodan Milošević.
The appearances, please.
For the prosecution, the prosecutor, Madam Carla Del Ponte, appears. I appear. And the court will see that I'm joined by Ms. Urza Retzlaff, who, as the court will know, has special responsibility for the Croatian indictment. My learned friend, Mr. Groom, sitting on the far right, who has special responsibility for the Bosnian indictment. And closest to me, my learned friend, Mr. Reinveld, who has special responsibility for the Kosovo indictment, the indictment that's going to be dealt with chronologically first in this hearing.
Yes, Mr. Kay.
For the Amici Curiae, Stephen Kay of Queen's Counsel of the Bar of England and Wales, Professor Mikhail Vladimirov of the Netherlands Bar, Mr. Branislav Tapuskovic of the Yugoslav Bar.
Madam Prosecutor, it's now for you to open your case. You will have in mind, of course, our order of the 4th of February relating to this trial, and that this part of the trial relates to Kosovo, although you have leave in your opening address to deal with other relevant matters to clarify the issues in the case. Before you address us, let me deal with one preliminary issue. We will grant your motion of the 8th of February for the withdrawal of exhibits and witnesses and the substitution of others. We are pleased to note the withdrawal of over 1,000 exhibits, and we would encourage such sensible pruning in the future. And I would add this: we will deal with any outstanding motions or other matters concerning this part of the trial later this week, and we'll deal with the conduct of the trial relating to the Bosnia and Croatia indictments on Tuesday of next week. That's the 19th of February. We will find a convenient moment during the evidence to conduct that hearing. Yes, Madam Prosecutor.
Thank you, Mr. President. Your Honours, the Chamber will now begin the trial of this man for the wrongs he is said to have done to the people of his own country and to his neighbours. How simple that statement is to make today, how easily those words pass into the record of these proceedings, and yet how remarkable it is that I am able to speak them here. Today, as never before, we see international justice in action. Let us take a moment at the start of this trial to reflect upon the establishment of this tribunal and its purpose. We should just pause to recall the daily scenes of grief and suffering that came to define armed conflict in the former Yugoslavia. The events themselves were notorious, and a new term, ethnic cleansing, came into common use in our language. Some of the incidents revealed an almost medieval savagery and a calculated cruelty that went far beyond the bounds of legitimate warfare. The international community was shocked to witness the vicious disintegration of a modern state, and the Security Council of the United Nations was quick to recognize the grave threat posed by the serious crimes it believed were being committed. This tribunal is one of the measures taken by the Security Council, acting for all member states of the United Nations to restore and maintain international peace and security. That is our purpose, and our unique contribution is to bring to justice the persons responsible for the worst crimes known to humankind. The crime of genocide, crimes against humanity, and the other crimes within the jurisdiction of this tribunal are not local affairs, and their prosecution may be beyond the capability of national courts. Crimes of the magnitude of those in the indictments before the Chamber affect all of us throughout the world. The law of this tribunal, international humanitarian law, is the concern of people everywhere. These crimes touch every one of us wherever we live, because they offend against our deepest principle of human rights and human dignity. The law is not a mere theory or an abstract concept. It is a living instrument that must protect our values and regulate civilized society. And for that, we must be able to enforce the law when it is broken. This tribunal, and this trial in particular, gives the most powerful demonstration that no one is above the law or beyond the reach of international justice. As prosecutor, I bring the accused Milosevic before you to face the charges against him. I do so on behalf of the international community and in the name of all the member states of the United Nations, including the states of the former Yugoslavia. The accused in this case, as in all cases before the tribunal, is charged as an individual. He is prosecuted on the basis of his individual criminal responsibility. No state or organization is on trial here today. The indictments do not accuse an entire people of being collectively guilty of the crimes, even the crime of genocide. It may be tempting to generalize when dealing with the conduct of leaders at the highest level, but that is an error that must be avoided. Collective guilt forms no part of the prosecution case. It is not the law of this tribunal, and I make it clear that I reject the very notion. I do, of course, intend to explore the degree to which the power and influence of the accused extended over others, but I stress again that the accused is brought before you to answer for his own actions and for his personal involvement in the crimes alleged against him. Your Honors, while I bring the indictment as prosecutor in the international public interest, I do not mean to ignore the victims of the crimes committed during the conflicts. Much of the development of the law since the Second World War has been designed to prevent members of the civilian population from coming to harm in times of armed conflict. The law itself exists to protect ordinary people not engaged in hostilities, even though, as prosecutor, I do not directly represent any individual victim. I do, however, consider it to be part of my function in presenting the case to allow the voice of the victims to be heard. No court can experience the events as the victims themselves did. and no court can be expected to do so. Many victims cannot come before you because they did not survive. Nor is it possible in the proof of crimes on such a scale, although in the indictments, for any prosecutor to bring all the surviving witnesses to give evidence in court. Despite that limitation, I am confident that the prosecution case will present to the Chamber a full picture of the circumstances of the crimes and of their impact on the people against whom they were directed. The case against the accused will be complex. It will be broad in its scope, reflecting the nature of the charges, and yet it will be detailed as criminal cases must be, where specific features of the evidence require to be explored in depth. This case will certainly test the criminal justice process itself and will challenge the very capacity of a modern criminal court to address crimes which must extend so far in time and place. I fully accept the responsibility that falls upon the prosecutor to bring forward evidence to support the indictment. A trial of this nature requires the Chamber to hear evidence from many sources, from individuals, from organizations, and from state officials. The Chamber will receive testimony from high-ranking military figures, diplomats, government representatives, and other persons of rank and function who, for different reasons the Chamber will understand, cannot be named today. Such persons do not commonly appear in the criminal courts, and receiving the evidence challenges equally the witnesses and the court. The witnesses must find in themselves the individual courage to give their accounts in public. I will seek to match their strengths by obtaining for them all appropriate measures of protection available under the tribunal's rules. Organizations and governments must also find the institutional resolve to place before the Chamber information, sometimes sensitive information, in their possession. In this regard, the trial will test the cooperation of all states, not simply the states of the former Yugoslavia, some of which in the past have obstructed the work of his tribunal and its prosecutor. Peoples throughout the world following these proceedings will be watching to see the extent to which their own leaders are committed to achieving the aims of international justice in this forum. This is a criminal trial. It is unfortunate that the accused has attempted to use his appearances before this Chamber to make interventions of a political nature. I can assure the Chamber that in the case before us, the prosecution will not allow itself to be drawn into any such exchanges. This is a trial chamber, not a debating chamber. I should also make it clear that in the performance of my duties towards this chamber, I shall not allow myself any advantage from the fact that the accused has chosen not to be legally represented. Under the statute of the tribunal, an accused is entitled either to defend himself in person or through legal assistance of his own choosing. He is fully entitled to exercise that choice and to elect to conduct his own defense. By doing so, he does not change the trial process in any way, and the onus upon the prosecutor to prove the case behind reasonable doubt remains unalterated. That is the position even where a prosecutor confronts a defense of defiance or where an accused refuses to recognize the court, or in some way attempts to undermine the solemnity of the proceedings. I speak for each of the Council on this side of the table when I say that, as the Chamber will be aware, the prosecution has scrupulously discharged its obligations at all pre-trial stages of this case. We regularly consider and will continue to consider with the Chamber and with the Amici whether mechanism can be applied to reduce any risk adverse to the accused resulting from his attitude to the court. I can further undertake to the Chamber that in the conduct of the trial, Prosecution Counsel, in the highest tradition of their profession, will do everything possible, despite the absence of Defense Counsel, to assist the Chamber to identify the issues as the evidence unfolds. Your Honours, permit me to say a further general word about the context in which the witnesses who may come before the Chamber will give their evidence in this trial progresses. It has been said many times that my mission as prosecutor is to bring before the institution the person who are believed to be most responsible for crimes in the former Yugoslavia. The international community expects persons at the very highest levels of command and leadership to be brought to justice here in The Hague. That task is the very definition of my mandate as prosecutor, and it is the essence of the purpose of the tribunal. With the trial of this particular accused, we reach a turning point of this institution. The proceeding upon which the Chamber embarks today is clearly the most important trial to be conducted in the tribunal to date. Indeed, it may prove to be the most significant trial that this institution will ever undertake. It is thus a trial that must inevitably mark the path towards the conclusion of the work of this tribunal, even although that day is still some way off. The trial also makes a change, as the court will discover, in that many people who have inside information are making the decision that it is right and better for them to assist the tribunal by giving evidence and by making their mark in the record of humanity. I recognize that this trial will make history, and we would do well to approach our task in the light of history. Sadly, ours is not the first inquiry into atrocities committed in the Balkan region. Listen to the words of the chairman of the International Commission to inquire into the causes and conduct of the Balkan Wars. Baron d'Estournel de Constant is writing of the wars of 1912 and 1913. He makes the point at the conclusion of his introduction to the report, published in 1914, that the real culprits are not the Balkan peoples. And he goes on to say this, quote, "The true culprits are those who mislead public opinion and take advantage of the people's ignorance to raise disquieting rumors and sound the alarm bell, inciting their country and consequently other countries into enmity. The real culprits are those who, by interest or inclination, declaring constantly that war is inevitable and by making it as though asserting that they are powerless to prevent it. The real culprits are those who sacrifice the general interest to their own personal interest, which they so little understand, and who hold up to their country a sterile policy of conflict and reprisals. In reality, there is no salvation, no way out, either for small states or for great countries, except by union or conciliation. Quote, Your Honors, no words could better set the scene for the matters this chamber will now try.
Let me make some comments in the French language. Before I give the floor to my colleagues, to Senior Trial Attorney Mr. Nice, he will probably need 4 or 5 hours, because that will be the very core of the indictments. And then the other senior attorney, Dirk Reineveld, will speak in respect of the details of the basic crimes in Kosovo, approximately 1 hour. Let me say, Mr. President, these few closing remarks. An excellent tactician, a mediocre strategist. Milosevic did nothing but pursue his ambition at the price of unspeakable suffering inflicted on those who opposed him or who represented a threat for his personal strategy of power. Everything, Your Honors, everything with the accused Milosevic was an instrument in the service of his quest for power. One must not seek ideals underlying the acts of the accused. Beyond the nationalist pretext and the horror of ethnic cleansing, behind the grandiloquent rhetoric and the hackneyed phrases he used, the search for power is what motivated Slobodan Milošević. These were not his personal convictions, even less patriotism or honor, or even racism or xenophobia, which inspired the accused, but rather the quest for power, and personal power at that. The trial which commences today will evoke the tragic fate of thousands of Milosevic's Croatian, Bosnian, Albanian victims. To read about the sufferings endured by these countless victims and survivors is unbearable. Yet the accused Milosevic also caused other victims. And now, Your Honors, I am thinking about the Serbs. The Serbian refugees from Croatia, from Bosnia, from Kosovo, abused by Milosevic, whose fears were fed and amplified and manipulated to serve Milosevic's criminal plans. Many paid with their lives. Most lost their homes and their futures. These men and women must rightly be counted among Milosevic's victims, just as the citizens of the Federal Republic of Yugoslavia, who now must reconstruct the exsanguinated country which Milosevic, the accused, bequeathed to them. The history of the disintegration of the former Yugoslavia and the fratricidal conflicts of another age which it brought about is a complex process which must be written by many people. This tribunal will write only one chapter, the most bloody one, the most heartbreaking one as well, the chapter of individual responsibility of the perpetrators of serious violations of international humanitarian law. It is up to other courts to make the moral, historical, or even psychological diagnosis of the accused and to analyze the social, economic, and political dynamic which constituted the basic fabric of the crimes that we are going to consider. The apparently inevitable concatenation of fear and hatred, political manipulation, the sinister role of some of the media, but also the heroism of the resistance and those who opposed him throughout the former Yugoslavia, the survival of dignity and civil spirit and humanity. All of these are mechanisms which must be analyzed, dissected, and explained. Because it is imperative to respond to the victims' demand for truth, victims in the broadest sense of that term, and to reduce the risks of seeing this played out again in another place in the world, and in particularly in the Balkans. But here, more modestly, it is Slobodan Milosevic's personal responsibility, which the prosecution intends to demonstrate, for the crimes ascribed to him. Nothing but that, but all of that. This is the contribution of justice, and we wish to make it dispassionately, recalling the words of Ivo Andrić, pronounced at the Jewish cemetery of Sarajevo, and I quote, "If humanity wishes to be worthy of that name, must organize its common defense against all international crimes, erect a barrier which is sound and sure, and truly punish all those who murder individuals and people." End of quotation. And I thank you very much, Your Honors. I thank you for your attention.
Yes, Mr. Knight.
On a day in November 1991, at the fall of Vukovar in Croatia, a man, I think he was 58, and his wife, fearing the worst, went to the hospital to find protection. What happened was that the men taken away by Yugoslav army soldiers, eventually to a farm called Ovčara, where they were beaten, jumped upon by the soldiers, subject to various indignities. The man who will be a witness before this tribunal, along with 6 others, I think, had the chance, good fortune of knowing one of the soldiers personally. So those 7 were picked out, and indeed 6 of them, I think, survived. The other 260 were slaughtered. Thousands died in the conflict in Croatia, and perhaps at least 170,000 more were deported. And so that account is an example of the misery and indeed of the criminality with which we will be dealing in the indictment that comes first in time chronologically, the Croatian indictment. A year or thereabouts later, in Visegrad, Bosnia, a young woman, heavily pregnant, found the town taken over by Yugoslav soldiers, and I think others, a group called the White Eagles, of which we will hear was involved. Because of what was happening, she and many other people took to the woods at night. Indeed, she gave birth to her daughter in the woods at night. And it would appear from evidence that we do have that she gave that daughter a name, but we can't tell you what the name is. In due course, that woman, her baby, and many others, including some 45 members of her extended family, were taken on the basis of a promise that they would be traveling in a Red Cross bus to a house that had been prepared for them with petrol on its carpets and presumably floors. And they were burnt alive. And the baby's screams were heard for some 2 hours before it too succumbed. And so that is one crime to represent the thousands killed in the Bosnian conflict, well over 7,000. A conflict that involves hundreds of thousands, 2, 3, deported. We move on 7 years to the third indictment, and to another and different story involving a mother and daughter. This time, not a young daughter or a daughter unborn, but to a girl about 20, old enough to think that she was perhaps an adult launched on life, young enough, no doubt, to have been regarded by her mother as the daughter she truly was. This is at a place called Kozice and thereabouts. At this site, as the court will in due course hear, some 50 women were gathered together for safety. And again, by deception and under guard of abusing soldiers, they were taken not to a mosque, as they were promised, but to a house that was capable of being made secure. The mother, from whom you will hear, and her 20-year-old daughter. The daughter was one of several women, mostly young, who were taken out from time to time by the abusing soldiers, returning in a state of obvious fear, it being perhaps a matter of inference what happened to them. Later, 8 women, I think 5 young and perhaps 3 a little older, were taken again, one of them the 20-year-old daughter. The house was tied up with wire, as the remaining women could see. They feared they were going to be burnt alive, but that didn't happen In due course they escaped, or they were let out, in fact. But the mother did not find her daughter. And in the weeks that followed, when she was free to revisit the area she searched, hopelessly looking for the daughter who was in due course found by those representing the international community doing their distressing work. She and the other 7 women last taken out were found at the bottom of 3 different wells into which they had been thrown, probably alive, and after who knows quite what had happened to them. And that account may serve as but one representation of what happened in Kosovo, where at least 4,500 people died, but estimates rise to 10, and where over 750,000 people were forcibly moved from Kosovo or forcibly removed within it. Those then, in some statistical way, and with just those examples, are the subject matter of this trial and these indictments. Having said what I've said, the court may want to know that I shall return rarely, if at all, to such distressing material again. And why? First, as the prosecutor has herself said, it is for the witnesses to come to this tribunal and to give their accounts, and it is to them that we shall look for the proper record. Of course, they will be but a tiny fraction of those who suffered, but the court will want to know that, for the most part, they are anxious to give their evidence, and indeed even those whose statements may be admitted by the provisions for the acceptance of written material in this tribunal, for the most part, they want their contribution to be public and clear as to who it is who's making it. So we leave it to the witnesses. Second, the distressing and emotive potential of this sort of evidence has, in truth, only one forensic value, point of forensic significance to this trial. The accused, as of course is obvious, is charged in respect of these events. The issue is, or maybe, did he know they were happening? Of course he did. Not only will matters have been reported to him, but in these days when the press, radio and television bring wars to our homes as they occur, he cannot not have known. And therefore the question is, if the chamber is in due course satisfied that he lay behind what was happening, why did he continue? Why did he not stop these things that were occurring? And third, as a reason for sparing the chamber an excess of distressing material, this: This accused and others who may come to this tribunal, or indeed to other tribunals, must know that whatever the underlying facts of crimes charged against them, trials will be conducted in a calm and unemotional manner. And perhaps one last reason why we should treat these events as dispassionately as possible. That's what, say the prosecution, the accused did. He did not confront his victims. He was able to view what was happening from the distance of high political office. And if the prosecution's case is right, he had these crimes committed for him by others. This trial, as again the prosecutor has correctly explained, will not be making findings as to history. Matters of history always leave scope for argument, for doubt between historians. But history, even distant history sometimes, available to this court through the witnesses, will have a relevance from time to time in showing what the accused thought, what those identified in indictments as his co-perpetrators thought, what his compliant supporters thought, and what was available in history to fire up the emotions, particularly nationalist emotions. However little this particular accused might personally and genuinely have held those nationalist views. For procedural reasons, this trial will start with evidence about Kosovo, despite that conflict coming last in time. But in a way, this may be curiously appropriate, for Kosovo features from first to last in the sequence of tragedies with which we are concerned, as well as holding, so it is said, a place in the hearts of Serbs and Albanian Kosovars as the cradle of their respective civilizations. The 1974 Constitution of the Republic of Yugoslavia gave Kosovo, as it did Vojvodina, semi-autonomous status. In fact, very considerable independence. Little Kosovo, barely over 100 kilometers from end to end, was hardly on anybody's lips outside Yugoslavia and on few people's tourist plans. It lies, of course, in the southern part of the Republic of Serbia, which is itself, or was itself, one of the constituent republics of the socialist Yugoslavian Republic. President Tito died in 1980. It may be that Serb nationalists believed that Tito had kept Yugoslavia together by weakening Serbia when he organized the semi-autonomous provinces within it. Maybe the phrase weak Serbia, strong Yugoslavia explained what he had done and why Serb nationalists felt as they did about it. Released from shackles, however beneficent, of Tito, exposed the population of Yugoslavia as a whole and its leaders to new experiences, new opportunities, and new temptations. And it was Kosovo that showed early signs of enthusiasm for change. As early as March or April of 1981, massive student demonstrations occurred in its capital, Pristina, in the town of Prizren and elsewhere, and the slogan, Kosovo Republika, was heard, coming as a surprise and indeed as a shock to many in federal Yugoslavia. At the same time, Serbian communists, and maybe Serbs without political affiliation, were becoming free to grumble about their historic lot and about Kosovo. The Serbian view may have included that it was they who'd been the valiant victors in World War I, the chief architects of the new Yugoslavia, the valiant victims of World War II, those who had won in war but lost in peace. And all, or very many, Serbs were willing to complain about Kosovo. Interestingly, at that early time, Kosovo may have found some support elsewhere in the Republic, in northern Slovenia, perhaps because seeing what was going to happen or what was happening in Kosovo, the Slovenians had anxieties for themselves. But the prevailing culture, perhaps difficult for outsiders to understand or to feel, was that this was a place where to speak in nationalistic terms was genuinely unacceptable, something likely to bring criminal sanctions. May it be that as thought became free, in part at least, it was easy for it to become distorted. And the Chamber will hear, I have no doubt, in the course of evidence, of a memorandum of the Serbian Academy of Sciences and Arts that was leaked in 1986. It's a memorandum, of course, of genuine intellectuals. And they were able, in 1986, to put their names to the following lines, and I quote, in translation, of course: "The physical, political, legal, and cultural genocide against the Serb population of Kosovo and Metohija is the serious defeat of Serbia." They went on in the memorandum to say, except in the wartime period, never have the Serbs of Croatia been so threatened as today. That then, the reaction of intellectuals in 1986 of Serb persuasion to what was beginning to happen in little Kosovo. How slight was the threat that the Serbs really faced compared with the threats that were to face others later? How could they sensibly use, in that context, the notion of genocide of culture? But the prevailing culture was one that could produce such thought, and there was much talk at the time of Serbs being vulnerable and under threat, concerned that the massacres of World War II, where they had suffered badly, so badly, would happen again, concerned that they would be drowned by the Albanians in Kosovo, or that they would somehow be exploited and oppressed politically and economically. It was onto this scene that this accused was propelled or propelled himself. And a question may arise when we consider this part of the history on the evidence, how this man, rare among former communist leaders, was able to effect the transition from party leadership under the old regime to party leadership under the new. Was he a brilliant and kindly leader, or was he simply a man who had the sharpest appreciation of how to retain control through manipulation? The fate of the late Ivan Stambolić may provide some answer. This man was mentor, in the political sense, to the accused, his protege. He sent his protege to Kosovo to quell unrest. He gave him an opportunity. It was an opportunity, and I'm afraid it's, of course, all now too well known. He gave him an opportunity which he took. Honor, we'll look now briefly at a piece of footage. Even if it is well known, it will have to be part of the evidence in this case. It's footage of the April '87 meeting in Kosovo. If the booth could assist us.
Da dođu ovde, drug predsjednik Milošević je dozvolio da uđu i oni.
I sad, mi smo kobajagi počeli sastanak, ušli su ti, ali napolju se samo čuje nešto. Mi ne znamo šta se događa. Ovi su naši bežali, što je ohrabrilo policiju, pa je ona krenula u dobar juriš. Dok su ove naše doterali do kamenja. Kad su ih doterali dotle, onda ovi naši okrenu tako da nijedan nije prošao bez poklona od narodne mase. Svi su dobili po 2, 3, po 5, po šlemu, po leđima, po glavi. I onda priđemo tamo opet do Miloševića i kažemo, napolje milicija tuče naš narod. I onda više nije mogao da prebaci loptu nikome. Ni da ide ovaj, ni da ide onaj. Onda on izlazi, verovatno je imao veliku tremu, uplašio se, preživljavao je strah, jer i on je isto, kao i mi, tako i on znao šta je sve u igri i šta je sve na kocki.
To what extent, if any, that incident was stimulated and planned matters little. It was that phrase, that you will not be beaten, and the response of others to it that gave this accused the taste, or a better taste, of power, maybe the first realization of a dream. It gave him an opening. The man who had sent him, his former mentor Stambolić, rapidly lost power, the accused gained power. By the 23rd of September of 1987, at the 8th session of the Serbian Communist Party, the accused achieved superiority over Stambolic, and in due course he was removed on the basis of what it may be was a totally incorrect or even forged document, and the accused became head of the ruling Communist Party. It's perhaps worth having in mind that it can never have been easy, or that easy, for a Serb communist to gain wide popularity. Serbs may have treasured institutions like the monarchy or the Orthodox Church or even the Chetnik movement that had been suppressed by communism. And it may be that Bosnian Serbs in particular felt this strongly and saw less or little good in communism. So for a former communist such as, or a communist such as this accused, to gain wide support was tricky, difficult, and he had to unite, if he was to have and retain power, the communist left and the anti-communist right. He had to obtain support of Serbs in Serbia proper, but also elsewhere in Yugoslavia. He had to weld them together, although much later, or later at any event, he would have to be releasing them, individuals when their purpose was served, and large groups of them in Croatia and Bosnia when his efforts at joinder failed. By 1988 and into 1989, the accused was enjoying considerable support. There was something called the anti-bureaucratic revolution, manifest in Vojvodina in something well known, I think, as the yogurt revolution because of what was thrown, and also in Montenegro. And to give us a taste of the times, it was in the course of these rallies, this anti-bureaucratic revolution, that pictures of the accused were everywhere, borne aloft in demonstrations, and perhaps as a result, both the provincial government of Vojvodina and the Republican government of Montenegro became places where support for the accused could be found. Indeed, in Montenegro, Bulatović, as president of Montenegro, came to be a great supporter of this accused. But his successes were not without difficulties. In October of 1988, there were demonstrations in Kosovo again against Serb nationalism and against the threats to the Kosovar economy and indeed its autonomy. In November '88, there were moves in the Kosovo Communist Party where people less loyal to this accused were replaced by those more loyal to him. And that was followed in February of 1989 by massive strikes, in particular of Albanian miners, against the threat of the revocation of Kosovo's autonomy. Can we get another snapshot of this accused at about this time. At the end of February or beginning of March of 1989, there was a demonstration. The subject was nationalism. We'll see the video in just a second. The accused spoke to a crowd of perhaps up to 1 million demonstrators in Belgrade. He spoke of settling accounts with Kosovo leaders and promised decisive action, but perhaps interesting is this. He kept the crowd waiting for a full 24 hours and then only spoke to them for 4 minutes. Can we see the clip?
Doći će drug Slobodan Milošević kao što smo obećali.
Nema te cene i nema te sile koja može pokolebati rukovodstvo Srbije i građane Srbije u borbi za pravedne ciljeve. Želim da vam kažem, ne čujem dobro, ali želim da vam odgovorim na ovo što tražite, da će oni koji su se poslužili ljudima da manipulišu radi ostvarenja političkih ciljeva protiv Jugoslavije biti kažnjeni i biti uhapšeni.
Well, the accused had learned, it may be thought, the power of the crowd. And in that interchange with the crowd, he responded to what was asked of him, and the man Vlasy, who featured in the communist shuffle that I referred to recently, was, I think, arrested the following day. But the powers of crowds are limited and ultimately reversible, as we will all recall from seeing on our television screens how it was that this accused eventually lost power so many years later. I return then to Kosovo, a continuing problem. In March of 1989, the Kosovo Assembly itself passed constitutional amendments contrary to its own best interests, abandoning or losing control of police, education, economic policy, the choice of the official language, and its veto powers over further changes of the Serbian constitution. At the time it passed those amendments, the Assembly building was surrounded by tanks, and there was uncertainty in any event as to whether the appropriate majority for the changes was present. It would not be surprising if such actions against Kosovo brought reaction. And I suppose the only surprise that one might have in mind now, and as we look at the chronology for the next few years of the chronology, is that the reaction of Kosovo, or of the Kosovo Albanians, was as muted and peaceful for a time as it was. Peaceful perhaps because Kosovo was left waiting, so far as it was concerned, for an eventual happy outcome. Waiting, it may be, on the accused's part, if he dwelt on it at all, for Kosovo's turn to come. People at the time of the conflicts in Croatia and Bosnia would say cynically or jokingly, that in the end it would end at Kosovo. On the 28th of March of 1989, the Assembly of Serbia approved the constitutional changes and revoked the autonomy of Kosovo granted in the 1974 Constitution. More strikes, massive in scale, responded to by brutal repression, up to 100 demonstrators killed, 1,000 people put on trial, including many of the Albanian elite. But this did not affect the accused's rise. For on the 8th of May, the time that these things were happening, he became, not by popular vote, but by the mechanism of the state appropriate at the time, President of Serbia. This trial is about the climb of this accused to power, power that the prosecution will invite the chamber to say in due course was exercised without accountability, responsibility, or morality. Such climbs cannot be accomplished alone. The help of fellow travelers is required, however quickly they may leave or be made to leave the moving vehicle. And from time to time we should just consider some of these men, co-indictees, some of them in the Kosovo indictment, others named as co-perpetrators in the Croatia and Bosnia indictments. Borisav Jovic, whose photograph is on the overhead projector, became vice president of the collective presidency of Yugoslavia. It's a body composed of various representatives of the states and the semi-autonomous provinces. This man was one of the accused's closest collaborators in the early days of the joint criminal enterprise charged against him, and was president of the presidency itself of Yugoslavia between 90 and 91 for a year. Through this man and others like him, say the prosecution, this accused exercised effective control over the presidency serving as commander-in-chief of the Yugoslav army, at that time known by the acronym JNA, and he was able to achieve that control despite being, the word only would be inappropriate really, but only President of Serbia. And perhaps I should just add this. Those who do not live in federal states and who look at them from a different experience may be tempted to think that it must be the case that the federal body is in some way all-embracing of, larger than, more powerful than the constituent states. That would be an easy mistake to make in respect to the former Yugoslavia. And it may well be the case that the federal body was weaker at various times, and certainly at the time with which we are concerned, than the individual state of Serbia. But that's for later determination. Returning to the man Borisav Jovic, in June of 1990, as the evidence will reveal, the accused shared with Jovic his view that the amputation of Croatia, the secession of Croatia, was to be exercised in such a way that various obstinas, regions of Croatia, remain with us, with Yugoslavia. At the same time, another man who becomes important at this time, General Veljko Kadijević, agreed with that notion, that Serbian obstinas, in the event of the loss of Croatia, should remain with us, the us then being, at least at that time, Yugoslavia. A seemingly innocent goal, but one that could be used to explain and to justify territorial aggression and crimes against humanity in the coming years. That general, General Kadijević, along with General Adzic, the chief of staff of the JNA, the Yugoslavian army, assured both Jovic and this accused that the military would in no case allow the Croatian police to occupy certain particular Croatian cities, which were by that point under Serb control. A word about the word police, as I shall use it in the course of this opening and as will be used extensively in the trial. The Minister of the Interior is known as the MUP, M-U-P, or the Minister of Interior Police is known as the MUP, the M-U-P. It comes in two parts: the conventional police, dealing with crimes, traffic, and so on, and another part which, to the uninitiated, will resemble far more a military force with substantial weaponry and appropriate vehicles. The relationship of Jovic and Milosevic before and during the war in Croatia, to which we will be turning in due course, will show in detail how this accused, although the President of Serbia, exercised control over that presidency of which I've referred and the army of which the presidency was commander-in-chief. And another point begins to emerge about this accused. First, guilty, culpable people often forget to do at the time what their innocence should have them doing. And we may find in the case of this accused, in the years that are to come, little or no expression of regret for what was happening to the victims of these conflicts. No sympathy. What thought process could enable him, whatever he was doing, to suffer this form of mental blindness? Well, now, part of the answer to that question may lie in the mechanism by which he controlled events. By being notionally separate from the body that was in law doing things, in this case the presidency of which he was not a member, he controlled events because he controlled the people who constituted the body that, as we will say in due course, did evil. So it was that body, not he, who bore responsibility. Never him, no regrets, no shame. Moving on just a little with Borislav Jovic before we return to the chronological examination of events. We will discover that from October 91, when there were absentees from the presidency because the representatives from Croatia, Slovenia, Macedonia, and Bosnia-Herzegovina did not exercise their powers, the presidency became what was known as a rump presidency, headed by a man called Branko Kostic, sometime vice president of the Socialist Federal Republic of Yugoslavia, named as a co-perpetrator, with Borislav Jovic playing a key role in it. And then it was the rump presidency, influenced, if not controlled, by the accused, that was able to control the Yugoslav People's Army, the JNA, territorial defense units and volunteer units acting in coordination and under the supervision of the JNA, and so on. So much for the time being of that man. We will no doubt hear in this case from at least one constitutional expert. It's right that the Chamber should have that material before it. Although there is a limit to the relevance of constitutional law to a man who, as the prosecution say, regarded the law as an instrument of rule rather than a controller of rulers. And the quick reality may be this: the units I've just described as being subordinated to and controlled by the rump presidency in due course that committed the gravest of crimes were simply, however indirectly, under the authority of this accused. And the rump presidency acted without dissension to execute his policies, so that the man Jovic would share responsibility for what was done by the army. But we'll come to that in due course. Returning to the rise of this accused and returning to Kosovo, we come to the 28th of June of 1989. Another, I think, famous clip, but we must show it, and it must be entered into the evidence of this case. On that day, there was celebration of the 600th anniversary of the Battle of Kosovo. I shan't trouble the Chamber with the detail of why that battle, which was indeed a loss by Serbians, was celebrated in the way it was. The event occurred at a place called Kosovo Polje in Kosovo. An enormous number of people attended. The accused was the lead speaker. The full speech will, of course, repay consideration in due course. The Chamber may think it is a skillful speech of great power, reflecting on how Serbs used to feel guilty for their role but should know more, how Serbs had been the bringers of freedom, basically how Serbs did and were good. But there was one passage, even in June 1989, that merits particular attention, and the clip that I will now ask to be played will show us what it was.
Drugarice i drugovi, na ovom mestu u srcu Srbije, na polju Kosovu, pre 6 vekova, pre punih 600 godina, dogodila se jedna od najvećih bitaka onoga doba.
I'm sorry, I was hoping that might be translated by the booth. If it's not happening.
Maybe that's something you can deal with during the adjournment, which we will take shortly.
Yes.
Is that a convenient moment?
I'm entirely in the court's hands, certainly.
The interpreters are ready.
A little earlier than I thought you would be rising.
Well, I have a message that the interpreters are ready, so let's try again.
Comrades, at this place in the heart of Serbia, on the field of Kosovo Field, 6 centuries ago, a full 600 years ago, one of the greatest battles of that time took place. The Kosovo heroism for 6 centuries has inspired our creativity, has fed our pride, and does not let us forget that we were once a large army, a proud army, a rare army who, in its loss, was not vanquished. 6 centuries later, today, we are once again fighting battles and faced with battles. They are not armed battles, although such battles are not excluded either. But regardless of the nature of those battles, the battles cannot be won without the decisiveness, the courage and perseverance and all the good qualities that were ever present a long time ago on the field of Kosovo.
So armed battles, armed struggle, was not being excluded even at that stage. And one other point about this gathering and what was said at it, which we will look at in the course of the trial. Happening on the territory of Kosovo, a speech that contained references to the values of a multi-ethnic society, but not one word about the Kosovo Albanians. By the end of 1989, it may be appropriate to remind ourselves the fate of Romania's President Ceausescu may well have caused fear in the minds and hearts of those who would be facing strong anti-communist sentiment generally. The skill and ability of this accused was to use such developing sentiments of anti-communism and to turn them by reliance on nationalism to his own advantage. For in the same way as he understood the power of the crowd, he appreciated that nationalism was a force. I return to what the prosecutor has already said, but in slightly different terms, to the same effect. Was the accused a nationalist? Maybe. Maybe not. In the same way as he most probably was not in any way a racist. There are those who believe in causes, and there are those who can seem to believe in causes. Only they know at the time which may be the truth. Others have to wait until later to discover from a careful examination of patterns of events whether the cause was an object of genuine pursuit or the passport to something else. The Chamber may in due course decide if it thinks it has to, but the prosecution invites caution before finding sincere adoption of a nationalist Serbian cause by this man. We come to the disintegration of the Communist Party of Yugoslavia in January of 1989. I needn't trouble you with a video clip for the meeting where the Slovenes and Croats left the party, although they remained in the presidency of the former Yugoslavia for another 2.5 years. The Chamber may remember from other sources how the Slovenes, I think, arrived at the last meeting with their suitcases ready for a quick getaway. Following that meeting, further demonstrations in Kosovo. Kosovo again. Demonstrations crushed by police, 27 killed. Now not an incidental, but a figure of comparative, not acceptability, but something. For, of course, a disintegrating society can have all too easily a corrupting effect on one's approach or the approach of people there to things like that. And we then reach the stage in the overall development of the history of the elections elsewhere and the growth of the nationalist parties elsewhere. I don't know if that's a convenient moment or not.
Yes, it would be convenient. We'll adjourn. Would the registrar just come up, please? We'll adjourn now till 11:30.
All rise, veuillez vous lever.